Code Enforcement Board meeting will be called to order now. Bobby, could you call the roll, please?
Mr. Weeks?
Here.
Ms. Wade?
Here.
Mr. Kramer?
Here.
Mr. Robinson?
Here.
Ms. Norfleet?
Here.
Mrs. Tilliard?
Here.
Mrs. Archer? Here. Mr. Video?
Perfidio, you got it. Here.
Thank you, sir, sorry.
Will you say it again, please?
Perfidio.
Perfidio, thank you.
Video. And Mrs. V. Casey is absent and excused. This completes your roll call.
Would the board attorney give us an invocation and lead us in a pledge of allegiance, please?
Heavenly Father, we seek blessings on the tasks before us. Bless our efforts with clear insight, our deliberations with wisdom, our work with clarity and accuracy, and our decisions with impartiality. We pray that our work this afternoon will find favor in your sight. This we pray. Amen. I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all.
It is the intention of the board to promote, protect, and improve the health, safety, and welfare of the citizens of Tarpon Springs by providing an equitable, effective, and inexpensive method of enforcing various codes within the city of Tarpon Springs. Any aggravated party may appeal a final administrative order of the board to the circuit court. Such appeal shall be filed within 30 days of the execution of the order to be appealed. Florida State Statute 286.0105 requires any party appealing a decision from this board to have a record of the proceedings to support such an appeal. The procedure of the board is as follows. First, the city presents its witnesses and exhibits, after which the alleged violator is able to ask the city witnesses any specific questions regarding their testimony. Secondly, the alleged violator is allowed to make a presentation and present his or her witnesses and exhibits. Then the city can question the alleged violator's witnesses. After both rounds of testimony, both on the part of the city and on the part of the alleged violator, each party is asked to give a closing argument, first by the city and then by the alleged violator. After those three steps are taken, this board will close the public portion of this case to discuss it and take appropriate action. Before we begin the public hearings, we will have all potential witnesses stand up and be sworn in by the secretary of the board. If you will now, please stand if you're going to give testimony. Thank you. And Bobby?
Do you swear the testimony you're about to give is the whole truth and nothing but the truth?
I do.
Thank you. You seated?
We have one more person that needs to be sworn in.
Back.
Ma'am? Do you swear the testimony you're about to give is the whole truth and nothing but the truth? Thank you, ma'am. You seated?
We're going to skip to number 4 on the agenda, a repeat violator, 19-800000701, 517 Ashland Drive, Irene Hoffman. If you want to step over there by the mic, I'd appreciate it, Ms. Hoffman.
I've never been here before, and this was my junior high school.
Ma'am, if you could just have a seat.
Can you just have a seat and let me know what your name is and what your relationship is to the property?
Okay, my name is Irene Hoffman. I own 517 Ashland Avenue instead of Drive, and the lot to the left as you're facing the property, which I don't believe has a numerical address.
At this time, we're only going to be handling the case from Ashland Avenue, you said, or Drive? Avenue?
Mr. Chairman, I have two cases, case 701 and 702. They're both her properties, they're both adjacent. It's the exact same story for both properties, so if you'd like,
All right, we can do both at the same time?
yeah, it's
Sure.
just rather than repeating the same thing. So if you'd like, I'd start out with 701, just because numerically it's the first case number.
Okay.
All right, Officer Steve Gasson, City of Tarpon Springs Police Department Code Enforcement. This is case before the board 19-800000701. It was formerly had a house on it. It does have a city address of 517 Ashland Avenue, but for the record, the parcel is 1427-15-43074-006-0070. And reference number, case number 19-800000702. It's the vacant lot next to that, also owned by the same person. Its parcel number is 1427-15-43074-006 and 0060. And as stated, they're both repeat violator cases. And the only thing I have is the evidence that we presented to her.
Do you have any evidence to?
It's been presented to her already.
Do you have any problem with the legal objection, rather, of the city evidence?
I don't, I like visiting this place as my former school. Mrs. Archer can attest to, I'm a retired school teacher. I'm a scaredy cat. I do like that to follow the rules. Mrs. Archer didn't even like to bring messages to my room because she'd know that I would panic. And so all of this is very embarrassing to me, and I do want to stay out of its clutches. I did note that when I purchased...
Could I interrupt you for just a second?
Yes, I want to talk about that property.
You certainly can, but at a proper time, if that's okay with you.
Oh, I don't know protocol.
All I ask you right now is whether or not you accept the evidence that the city has into any legal objection to that.
Okay, well, Vince from Ken's Tree Service was called out because he's done great work.
No, ma'am. Just, you don't have
I
any
don't know if
legal
I accept
objection
it.
to
I
evidence.
don't know if I accept it, simply because he complied with what the city or the code enforcement told him to do.
Have a legal objection. What is your legal objection?
That he did what he was supposed to do, and someone came out and said, I want that to be re-inspected.
Okay, that's not a legal objection.
I
so-
don't know. This
so,
is all I know.
Mr. Chair, I would suggest that you just overrule the objection and let the evidence come in. The other option would be to sustain her objection and just let the city staff make a presentation.
I'm going to do what's...
Hold on a second, ma'am, I'm talking
okay.
to the board, okay. So those are your...
I'm going to overrule your objection. Go ahead.
All right, thank you. Exhibit number one, going before the board for both cases, is going to be the photographs. Exhibit number two, again, for both cases, is all my notices, to include notice of violation and notice of hearing. Exhibit number three are administrative documents, including the case summary, property, or previous board orders, property appraiser, and tax collector records. Exhibit number four is the affidavit of posting and a copy of the sign. And affidavit of prosecution costs for each case is exhibit number 5 for the record. All of the photographs and exhibits that were given to the violator, exact copies of what's being presented to this board. All of my notices are mailed to the property owner of record as determined by the Pinellas County Property Appraiser and Tax Collector databases. All notice of violations and notice of hearings are sent both return receipt as well as first-class mail. And Mr. Chairman, please accept all these exhibits into the record as evidence for both cases.
Thank you. And
Just
Sure.
that it has been,
He's
those
not finished with his
photographs are
case,
not...
Mr. Chairman, this is he's just presenting his evidence, and so you need to receive that into evidence, and then he needs to present his testimony.
Bobby, would you receive this into evidence, please?
Yes, sir.
Sorry.
Steve needs to present his testimony.
Right, they're not, that's not what the property looks like now.
All right, thank you. We have had previous contact with the owner, both via phone calls, and we've also talked to a maintenance manager who was taking care of the property. This case started out on September 27th of this year. It was a complaint. I observed the property is overgrown and not being maintained. On September 27th, 2019, the repeat violator notice of hearing was mailed. Green cards were returned unclaimed. On October 8th, I conducted a reinspection. At the time, it was not in compliance. Only one part of the lot was cleared. This is a situation where the lot is less than 10,000 square feet. The parcels are not yet combined, so they're two individual parcels, and they're each less than 10,000 square feet. So the requirement in the city code 852 requires that the lots be completely clear below 12 inches and don't have any noxious plants, weeds, things like that. So that's in effect for this property. Also, the property had been previously cleared. It used, like I said, it used to have a house on it, so it's been developed property, if you will. So on November 1st, I posted the property and signed the affidavit of posting. I conducted another inspection on November 8th. It was in compliance. This is another situation where we backdated the compliance to 11/4 because they had contacted us, said they believed they were in, but I wasn't able to do the inspection for 4 days. So, I'm sorry. Actually, we backdated it more than that. I hadn't finished reading yet. So we changed the compliance date back to October 29th because that was the day Ken's Tree Service had completed the work. I just hadn't had an opportunity to go out and re-inspect it. So the compliance date for the record on both of these cases is October 29th of 2019. As stated, the property was in violation from the date of inspection on September 27th. Until it was complied on October 29th, which is 28 days, I think, according to my math. And they were in violation of Section 8-40, duty to maintain private property, and 8-52. Now, as far as case number 701, it's a repeat violator for case number 17-800000552, which was a violation of the same two codes, 8-40 and 852. Case number 702 is a repeat violator from case 17-800000552, again for the same two city codes, 8-40 and 8-52. And at that point in time, the previous case, they were found in compliance before the fines accrued. So we have no pending fines at this point in time.
What fines were assessed with the previous case?
It was $25 a day on the previous case.
Thank you.
Anybody else have any questions for the city?
Would this be a question concerning the evidence that we just passed? If I had a question?
If you're asking
I
me,
have
I
a
think you
question
can
about
ask
something
anything.
that was passed.
Oh, certainly, I think you can ask that, yeah.
Okay. What type of a public nuisance does that cause?
Because of the overgrowth, harbor snakes, rats, trash, people hide in the woods. It backs up to the church, their property. The church on the bayou is to the south of her property. As a matter of fact, when they cleaned it out, they did find a pretty substantial rattlesnake in there. So by having that property cleared, you don't have those public nuisances. So that's why it's attached with it, that goes along with it. Specifically defined in the code as one of the nuisances under 8-38, 8-39, and 840.
Thank you.
You're welcome.
Does any other persons from the board have any questions for the city? Ma'am, do you have any questions for the city, please?
Yes, why, when I purchased from the city, the property that does not have a street number on it, it was heavily wooded for a very, very long time. And when I purchased it, it was heavily wooded. And I was told by someone we may know here that the city doesn't mind if they own it to allow it to grow and be woods-like. But if you purchase it,
Ma'am, I'm only asking if you have any questions for
that's my
Officer
question.
Gasson.
How does that work? If the city does not maintain or clear specified, can the city be okay with a lot that was for many years wooded? I came along and I purchased it. As soon as I did, it was, I mean, I came to discover, because I'm so ignorant and innocent about these things, oh, by the way, you just purchased that property? My question is, the city doesn't maintain it. Is that okay for the city to have it so heavily wooded with no apparent?
Let's go ahead and ask that question to Officer Gasson.
I can't account for anything the city did prior to me becoming the code enforcement officer. So I legitimately can't answer that question.
Okay,
So, and I
It's
have
a
no idea when you
legitimate
purchased the
question.
property, so.
very legitimate.
Now, you have an opportunity now to present your case. Do you have any evidence, or
I'm just, I'm going to have that property cleared. I do not like coming here. I don't like the authoritative feel of, you know, being how we're situated, and I don't want to come back here again. And Pete Delakis has wanted to be a witness for me right now, but he can affirm that that lot was severely heavily wooded, and I'm saying severely, not in a, like, severe, but severely heavily wooded, and when the city owned it, there was no regard. So I assumed that continuation. So, I
Okay.
think Pete's more adroit at doing this. I have no idea, because I haven't done it before. I call you as my witness.
Peter Delakis, 514 Ashland Avenue. I'm here as a witness and also as a rebuttal to testimony of Officer Gasson. Ms. Archer brought a valid question forward. Where is the public nuisance? Who is the public nuisance? If you don't know the area, this area is heavily wooded in here. There's Hidden Lake back here. Behind the church, there's a lot of wooded area. If you look on your map or your picture there, that road dead ends there at Ashland. And all behind that, is all wooded. And behind that section there is Legion's Lake, which is behind the Baptist church and behind the fire station and behind the old veterans post. Now, all of this area is heavily wooded. Part of the reason we like living back there is it does have its nature. Again, being that this is off on a dead-end road, legally it's platted where Ashland is on the other side. If you were to turn down by right by Jimmy's and the daycare center, you go straight south, and then there's another extension of Ashland. So originally, years and years and years ago, this was platted to go through, and there are platted lots in here, but none of them are developable. Now, I can understand if this property was on Whitcomb Boulevard.
Objection, relevance.
No, I would continue. I would say that if this property
Chairman, I have an objection.
was somewhere, allow me to continue, please.
Hold on a
If-
second,
Hold
Peter.
on.
Excuse me.
He's raised a legal objection.
Okay, and what
The
would that
chairperson-
objection be?
Wants to know what the relevance is.
The relevance is how this property is a public nuisance. How is this property a public nuisance when it's not in the visual or normal travel patterns or of most people either coming to Tarpon, visiting to Tarpon, or transmitting through to go various places? Now, I do
Hold on a
understand the
second.
fact
Hold on a
of,
second. You've responded to the question. So, Mr. Chairman, you need either sustain the objection that the conversation about homes on Whitcomb Bayou are relevant, and if you find that it's relevant, then you would overrule the objection. Otherwise, you would sustain it, and you would not be able to continue on, Mr. Delakis, about other properties unrelated to this one. So, Mr. Chairman.
Sustained.
Okay, so the objection sustained. So, Mr. Delakis, if you could just keep your
okay.
testimony directed to this particular property.
Okay, so again, I will go back to the fact of who is this a public nuisance to? Who is this affecting? I moved into my house in 1994. as Ms. Hoffman has
really
stated.
don't see any
No,
relevance.
this is
I
very
s-
relevant,
don't
sir.
see
If
any
you allow me to
relevance to this.
continue, please. This is relevant to the
Black
facts,
is-
No.
please.
He is the chairman of this meeting, and you need to pay attention to what he's saying. He's telling you it is not relevant, so don't continue on to talk about any property other than the one we're here discussing
I am
today.
talking about that
No,
property.
you're talking about your
you're talking about-
property.
No, I'm saying I moved into my property in 1994 across from this lot. I did title search on this property. The city acquired this property, I believe, in either the late 30s or early 40s as a donation. So this property has been
We're only here-
untended
Mis-
for over 65
Mr. Chairman, I would
years.
object again to
I
relevance. We're
totally
talking about that.
object, and he objects. And you're way off course, sir.
No, sir, because
Yes,
this is
sir, you are.
relevant to the property.
Do you have
This-
any other witnesses?
I am not completed my statement, sir,
Believe
with
you
regard.
have.
No, sir.
Yes, you
Because
have.
Mr. Gasson said that it was a nuisance because of rats and snakes. And I will also say, as a woodland area that it had developed, there were also owls
No.
and hawks and other things.
Sir,
And
could
I
you
even
please
have a
stop
photo
talking?
of a gopher tortoise hole that is
We
in
need
the
to move
property,
on.
such that it is
On
not
now.
a public nuisance with
is a public
regards to the
nuisance.
animals. The animals live there, and that was providing them a place. There was nobody in our neighborhood who was complaining about this. And the city had this
Again,
property
objection to
for
Action is
years,
sustained.
and it was not
And he has
attended.
to stop
And
talking.
once Ms. Sackleson Hoffman received it,
If you don't
then
stop,
we
we're going to
began.
have you removed from the building. Do you understand? There's been an objection, it's been sustained, so you need to move on. So concentrate on this particular property.
That's what I'm talking about. This property is not a nuisance.
Okay, they've heard that 3 times from you now. That's duplicative testimony. Do you have anything else that you wanted to add?
We're done.
Any questions for the owner of the property?
And you can ask questions of Mr. Delacus, too. He's testified.
Does the board have any questions of Mr. Delaxis? City have any questions?
I do not.
Would you like to summarize the case?
Briefly, just for the board's satisfaction, definition of a nuisance under city statute or ordinance 8-38. It states a nuisance, the conduct specified in this article and chapter 4 of this code, any continuing condition or use of premise or of building exteriors of land which endangers or injures the comfort, repose, health, and safety of others. That's subsection 1. Subsection 2, unlawfully interferes with, obstructs, or tends to obstruct or renders dangerous for passage any public or private street, highway, sidewalk, stream, ditch, or drainage. 3, in any way renders other persons insecure in life or the use of property, or essentially interferes with the comfortable enjoyment of life and property, or tends to depreciate the value of properties of others. I can go through the definition of person, premise, and vehicle, but I think they're fairly common sense. Basically, in a nutshell, regardless of where you live in the city of Tarpon Springs, your condition of being a quiet street versus living on US 19, Whitcomb Boulevard, or any place else, all follow the same code. I try to establish that same non-biased approach to wherever the property happens to be. That's this particular case. I don't know the history of this property. I started to deal with it in 2017. The property was demolished, and that's my history of it. But by the photographs that went before the board, you clearly saw that on the date I inspected it, it did not meet City Code 8-52, which is not being properly maintained. 8-40 is just one that goes along with it. As the board can appreciate, even if 8-40 wasn't on the table, 8-52 is. So it's a kind of an all or nothing issue with, are they in violation? I would tend on the city's behalf that duty of maintenance of private property, 840 says no person owning, leasing, operating, occupying, or having control of any premise within the city shall maintain, keep, or permit any nuisance as defined in 838, which I just read, and is further defined in 8-41, which has got a whole nother list of potential nuisances or violations. I think it's very clear under 840 and 838 that this property meets that condition. And then going along with 852, it's clearly overgrown. We've seen snakes in there. That's a danger to people. There's a house next door, there's a house across the street, there's a house on both sides, actually, and a church behind it. As you can see by the picture, it's substantially residential, and then you go to the south is the church. So, yes, there are some wooded areas, but there are residential areas very close to that property. So, that's all the city has. Yes, ma'am.
I did have a question. So should we find that they are at fault, do we have to double what we're doing, or can we consider this as one item?
It's two separate motions, two separate agenda items. So it needs to be addressed separately because they're brought to you in separate cases. It's, so.
701 and 702.
Okay.
I have a question, and only one of them had a prior fine.
They were both, they were together.
Fine for both of them.
Yeah, but the fines were never levied. That's
Okay.
what the board had suggested as a fine,
Okay.
but they came into compliance, so no fines were ever levied
Okay,
on either of them.
okay.
Were noticed on September 27th, compliance did not occur for 28 days.
Correct.
Thank you.
Do you have a summary of, that you want to address?
I just merely
Ms.
like to explain that as soon as I get notice, and the one envelope that's certified is a duplicate of what they send to your house. My house burned down a year and 3 months ago, and I'm still not in it, so I live elsewhere. And they wanted me to pick it up at the Holiday office, but I knew, so I immediately made a call to Beth, and then I made a call immediately to Vince at Ken's, who has an alliance or some kind of connection here, and he truly believed that what he did, because he spoke to this office here, that what he did was what was necessary, because he asked. Once it came known to me that it wasn't, I was at the mercy, because I will use Ken's tree service, I was at the mercy of when he could schedule to come out with his crew to do the work. It was $3,500, and to keep it maintained, I don't know what it's going to cost, but I will have that done. I would like not, I humbly say I would like not to visit here again. I'll jump. I'd rather not to have any kind of government interference, but if someone asks me, I'll jump to do it. But Vince is working out where I can have regular watch and maintenance over this beautifully wooded area. It is a beautifully wooded area, but an oak tree that didn't have any signs of anything happened to fall on the rental house, so that was demolished, and I was not able with enough insurance money to bring it back to where it was. It was a rental house, so not quite enough. They gave me everything, including my deductible, but it wasn't enough to bring the house back. It was my question, is there some discrepancy of city-owned property being able to be wooded versus someone privately owning the property? And two, if Vince, because I don't want it to appear that it was a protracted amount of time that I was sitting back just twiddling my thumbs. I do believe I had correspondence with Beth telling her that I want to rectify the situation because I don't like my name to be on public record or anything else. I like to be squeaky clean. That time frame, I was pretty much at the mercy of when Vince could schedule a crew to come out. And then the disappointment, the question is when Vince had discussion with his liaison in the code enforcement, he did, for $1,500, he did what he believed from talking to the front office there, what was necessary. When it was discovered that it wasn't that wasn't enough, and the lots do not look like that today. They're much more cleaned out, unless somebody has just come in very recently. They're cleared. But he believed that he was satisfying, and then he assured me, because I'm his customer, I'm his client, and he very much wants to please me and help me without draining the bank account. And he phoned me and he said, "We're good. I've spoken to the code enforcement. We're good." Well, it turns out that shortly later, I had to call Vince, and Vince, "We're not good." And he said, "What?" I said, "No, we're not good." And I said, I can't go out there with a mower. I can't, these are now very expensive liabilities, these properties. They just sit. Property taxes you pay, and, it's expensive. But I will say this, I am a rule follower. I don't want to come here again,
Okay.
and I want to pay what I have to do, and I want to be done with this today.
All righty.
Mr. Chairman, may I ask a question
Certainly.
to Ms. Hoffman? Ms. Hoffman, how long have you owned this property?
The one property to the right, I believe I bought in 2006 or 2007, and the property to the left, maybe 3 years ago, 4 years ago. It could be a little bit longer, but I haven't owned it long. But I saw it all the time because of my rental house, and I saw what it was like, and I liked it. It was very pretty. I didn't see anything dangerous, but I loved the foliage very much.
Let me ask.
The Florida wooded.
Officer Gasson, isn't there woods behind that property also?
Yes.
And at that point, I'd like to clarify the difference between property that has once been cleared and property that has never been cleared, because the laws are different for the two.
Correct.
This once had a house on it.
Yeah.
Therefore, it had been completely cleared, maintained at some point, and that has to stay, even though the house is no longer there, because once the lot has been cleared,
It's developed property in the city. And the other caveat to that is it's less than 10,000 square feet.
Yes.
The other caveat to that is she didn't have to clear the rear of the property. Any large trees, anything over 4 to 6 inches, diameter, that's not what we're doing. We're not going and clearing a lot. You have to get rid of the undergrowth, the weeds, the plants and things like that, but the trees are still there. It's not a barren landscape now. It's, I don't want anybody to think that we went and just scavenged the land. So, but it has been significantly cleaned up and it is in compliance, so.
thank you.
And
The
you
question,
wanted-
the question that I had was, when was the house demolished that was on the previous lot?
This is 2019. My house burned down 2018, and the year before that, the oak tree fell on my rental house and crushed it. So I'm going to say 2017 is when, and I had Mr. Levinson come and demolish the house at my expense. That wasn't insured covered, but it was a very beautiful backyard. The one to the left, that property to the left, was always wooded, which I loved dearly, and so did the tenant. The tenant loved it wooded.
Okay. The lot, once it's cleared, has to be maintained clear.
Correct.
Bottom line.
Under
Thank you.
continuous same ownership.
Thank you.
Board have any more questions? I'm going to close the public portion of this case and ask the board for a motion.
I move, based on the testimony, evidence, facts presented in law, that Irene Hoffman was in violation of Section 8-40 and 8-52 of the Tarpon Springs City Code from September 27th until October 29th, a time frame of 28 days, and it is now in compliance, and a fine of $25 per day for those 28 days, or a total fine of $700. In addition, I move that the city be awarded $69.50 for the cost incurred in prosecuting the case.
I'll second that.
It's seconded. Any discussion? Bobby, would you call the roll, please?
Ms. Telliar?
Yes.
Mrs. Archer?
Yes.
Was that a no, Ms. Archer? You said yes?
That
I'm
was a
sorry.
yes.
I'm sorry, I didn't hear you. Mrs. Norfleet?
Yes.
Mr. Robinson?
Yes.
Mr. Kramer?
No.
Ms. Wade?
Yes.
Mr. Weeks? Yes. Motion carries.
Okay, you want to move on to the
Would
second case, and then I'll summarize both? So we
No,
just-
on the second case, would you entertain a motion on 702?
I move that, based on the testimony, facts presented, and law, that the respondent, Irene Hoffman, was in violation of Sections 8-40 and 8-52 of the Tarpon Springs City Code from September 27th until October 29th, and a fine of $25 per day, or a total of $700. In addition, I move that the city be awarded $69.50 for the costs it incurred in prosecuting the case.
Seconded. Bobby, could you call the roll, please?
Mrs. Telliar?
Yes.
Mrs. Archer?
Yes.
Ms. Norfleet?
Yes.
Mr. Robinson?
Yes.
Mr. Kramer?
No.
Ms. Wade?
Yes.
Mr. Weeks?
Yes.
Motion
Okay.
carries, sir.
Motion carries. Now, could you
So,
summarize?
Ms. Hoffman, I'm going to go ahead and summarize what has happened today. So the Code Enforcement Board has found a violation on both properties that were cited, found the property in violation of Sections 8-40 and 8-52, found they're in violation from September 27th until October 29th, and assessed a fine of $25 per day on each property, plus $69.50 for costs of prosecuting the case. If you have any questions about what has happened today after the meeting, you can contact the code enforcement staff, and they'll be happy to answer. There will be an order entered. It'll be entered within the next 10 days. It'll be sent to you at the address listed by the property appraiser and tax collector's office. If you have a different address that you wanted to give the code enforcement board, or code enforcement staff, you can do that during this meeting, okay? All right, thank you.
Thank you. 19-80000691.
We're on what number are we on?
We're on number 2 now.
Okay.
Dina Ruth Gorham?
Okay.
601 East Martin Luther King Jr. Drive. No one is present for this case.
Okay. Thank you, Mr. Chairman. Officer Steve Gasson, City of Tarpon Springs Police Department Code Enforcement, case before the board 19-80000691. Property address is 601 East Martin Luther King Drive. The property owner is listed as Deanna Ruth Gorman. And nobody's present for it. All the photographs regarding this case are exhibit number 1 going before the board. All my notices of violation and notice of hearing are exhibit number 2. Exhibit number 3, administrative documents, case summary, property appraiser, and tax collector records. Exhibit number 4 is affidavit of posting and a copy of the sign. All notices were mailed to the property owner of record as determined by the Pinellas County Property Appraiser and Tax Collector databases. All notice of violations and notice of hearings are sent, both first class and return receipt. And please accept all the exhibits into the record as evidence, Mr. Chairman.
Bobby, please do that when it gets to you.
Sir.
Moving forward, we've had no contact with the owner in reference to this case. This case started on September 25th of this year. There's a tarp on the roof. It's been there for quite a while. There were other violations that are already open cases that are currently drawing fines. On September 26th, the notice of violation was mailed, returned unclaimed. On October 31st, I conducted a reinspection and there was no change to the property. Same day the notice of hearing was mailed, no mail was returned to our office. On November 1st, I posted the property and signed the affidavit of posting. On November 13th of this year, I conducted another inspection, and again, there was no changes to the property. Before the board is violation of Section 8-40, duty to maintain private property. 6-1 adopts the 2018 version of the International Property Maintenance Code, and under the International Property Maintenance Code, Section 304.7, requires that you basically have a roof intact and proper drainage, and typically when you have tarps on your roof, you're indicating there's something kind of not working correctly with your roof. So. And we passed you the wrong photos, so we will be passing the correct ones down to you. That's one photograph of the front of the property, which you will see here in a second. And this is another photograph. Clearly showing the tarp. And like I said, it's been on there for a while. I apologize for it not kind of making it on the previous cases. It was after the storm and a lot of people had tarps on their roof. We got a complaint about this one, and that's why it's now before the board. Other than that, the city has nothing else.
The board have any questions for city staff?
Yeah, I do. I noticed there is another case involving a request for a fine reduction by the person of the same name. Is there any relationship between these two that is pertinent to this case?
Not to this case, but it's the same person.
And
So-
they didn't answer you, you said that nobody responded, but responded
Correct.
to this other case.
Correct. There's some other circumstances with that other case that, if you'd like,
We'll
we'll
get to
discuss
that.
then.
I understand. But I just didn't understand why they would talk to you about the one case but didn't talk to you about the other case.
Have no opinion on that.
Okay.
Would you like to summarize?
I think I've covered it.
Could you please repeat the date you posted the property, Officer Gasson?
It's on,
I'm sorry.
The date that you posted the property?
I posted the property on November 1st.
Okay.
See this every day.
in your packet, you got it today. Whatever she gave you today.
Another question, I'm sorry. The property is listed as homesteaded.
I do not know.
It is,
Oh, okay. I didn't know it was a rhetorical question. Sorry.
Yeah.
but there's no one living in it.
There's people living there,
There's
yes.
people living in it.
Yeah, it's occupied.
See, you need to go by, what are we waiting on? What are we waiting on?
We're waiting on
Oh,
the evidence to get down to,
And
The
that
last
has
board
a
member.
September 25th date of noncompliance? But the notice,
The case started on September 25th. That was the initial inspection.
okay. We're going to close the public portion of this case right now, and I'll entertain a motion.
I move based on the testimony, evidence, and facts presented in law that at any time, that at the time of the alleged violation, sections 8-40, 6-1 of the IPMC Building Code, and 304.7 of the IPMC Code of ordinances of the City of Tarpon Springs was in force and effect, the respondents were in violation thereof.
Second.
Bobby, roll call?
Ms. Telliar?
Yes.
Mrs. Archer?
yes.
Mrs. Norfleet?
Yes.
Mr. Robinson?
Yes.
Mr. Kramer?
Yes.
Ms. Wade?
Yes.
Mr. Weeks?
Yes.
Motion carries.
You doing the second one?
I move that the respondent shall have until December 10th to bring the property into compliance with code sections 8-40, 6-1 of the IPMC code, 304.7 of the IPMC code, or suffer a fine of $50 per day for each day thereafter that the respondent remains in violation of said code sections.
Second.
There's been a second. Bobby, could you take a roll call, please?
Helliar,
Yes.
Ms. Archer,
Yes.
Ms. Norfleet,
Yes.
Robinson,
Yes.
Mr. Kramer,
Yes.
Ms. Wade,
Yes.
Mr. Weeks. Yes. Motion carries.
Okay, next item, repeat violator 19-800000699, parcel 132715 67896 0000110 vacant lot next to 439 Lincoln. Craig Fowler, Jr. Could you state your name and the relationship you have to the property in question?
Craig Fowler, the owner.
Thank you. And this lovely lady with you?
Yes,
Mother.
I'm his mother, Priscilla
Oh,
Hudson.
okay. Okay, great.
Mr. Fowler, did you swear in?
Yeah, he hasn't been sworn in. No, she was sworn in, he was not.
She's doing my talk.
Okay.
She's doing that
Take
talk.
care of that real quick. Will you raise your right hand for me, please? Do you swear the testimony you're about to give us whole truth and nothing but the truth? Thank you, sir.
You want to start, sir?
He was provided with some evidence.
Oh,
Any
okay.
objections?
You're going to provide us with some evidence?
Actually, no, I'm sorry, sir, we didn't bring any evidence because this is
No, I
our first
gave him-
appearance, so we wasn't sure what to do. We're trying to find out what's,
I gave him evidence to be reviewed.
no, these are forms that the lady handed us.
Okay.
Any objections to that being received into evidence, the photographs and the paperwork that the city staff has provided?
No, we have no problem with this, but all this been taken care of. That's why I say I wish I would have brought the form, the
Okay, you'll have,
evidence, but,
we'll have the opportunity to hear you on that, so.
Okay.
Mr. Chair, we can accept that into evidence then.
Okay. Go ahead and present your case now, sir.
Thank you, Officer Steve Gasson, City of Tarpon Springs Police Department Code Enforcement. Case before the board is at 19-800000699. It is a vacant lot that's kind of surrounding 439 Lincoln, both to the north and to the east. And it is a repeat violator case. The case was 19-800000317 that established it for violation of City Code 8-52. The parcel number as stated was 132715 67896 0000110. Property owner is Craig Fowler Jr. Exhibit number 1 going before the board, or any of the photographs that I took. Exhibit number 2, notice of violation and notice of hearing. Administrative documents, case summary, previous board orders, property appraiser, and tax collector records are exhibit number 3. Exhibit number 4 is the affidavit of posting and a copy of the sign. And exhibit number 5 is the affidavit of prosecution costs. All the photographs and exhibits that were given to the violator are exact copies of what's presented to this board. All notices were mailed to the property owner of record based upon the Pinellas County Property Appraiser and Tax Collector databases. All notice of violations and notice of hearing are sent both first class as well as return receipt. And, Mr. Chairman, please accept all exhibits into the record as evidence.
Board have any questions for,
We'll receive that into evidence.
receive this in the evidence, I'm sorry. Bobby, when it gets to you?
Yes, sir.
Thank you. We haven't received a direct call from the owner. We have received calls from the relatives. The case started on September 30th, 2019 was my initial inspection. There were shopping carts and trash dumped on the property. On September 30th, the notice of violation, the repeat violator notice of hearing was mailed. The green card was returned signed. We just couldn't, the signature was illegible. On October 18th, they conducted a reinspection, and it was in compliance for part of it because there was two separate violations. There was a repeat violator under 852, which is debris and things like that. And then the other part, which was trash, was in compliance. So it's kind of a partial in compliance. The board's not hearing anything about 822 because he's in compliance. I posted the property on November 1st. And on November 5th, the amended repeat violator notice of hearing was mailed, and the green card was returned signed. The property in violation from date of inspection on September 30th until its compliance on October 18th. So it was in compliance on October 18th. And it was in violation of City Code 8-52. So I think Ms. Hudson's going to say that it's in compliance, and it is. I put it in compliance on October 18th. I think we got the office called. Your circumstances are just different.
Wrong address for my son, therefore, that's why we're not getting the forms till later on down the line.
We can take care of that afterwards.
Take care, yeah, but everything's taken care of. We got all the grease bucket, everything's on this picture, all that is taken care of.
Right.
Like my son, he's disabled, so we try to find someone to come out. I mean, he can't come out day and watch. We can't control what someone, throwing out property, whatever, his property. So we try our best to keep it, taken care of, We got people that lives back there now that's constantly out there every night, and we try to go by it every other day and check on it now. But my suggestion is we try to put up trespassing signs now. Hopefully that will help, and that the Tarpon Police Department will help with us as well.
What do you mean, people are walking somewhere or
I mean,
something?
as you can see, they just throwing trash out there and on the property. How can we control that? Our job is to come out, every now and then and, get a maintenance guy to keep it clean, but apparently someone's doing this daily, I guess, so we're not sure until we get the notice, We're not out there every day checking on the property.
But he lives at the property.
Yes, my son, he's the owner, yes. But I
You're-
just help him out because, he's disabled, he's not able to do.
But he doesn't live at the property.
No.
Craig, you don't live at the property, do you?
No.
Okay,
So
just,
you
that's
rent it-
clear. There's no rental on the property. It's
No.
just a garage, is that correct?
Yes, like for storage, it's
Okay.
like.
Craig, do you have any questions for Officer Gasson in reference to his
No.
discussion?
Not sure if my mother does.
Would you like to present any kind of case, or you have your mom do it, or? Could you put the microphone closer to
No,
your
I'm
mouth?
saying that if she wants to do it, she can. It's up to her.
Yeah, you don't like to talk.
All right. Well, we certainly heard from you already, and did you want to say anything else?
I mean, how can we solve, we want to solve this today, we try not to have high fine or whatever. But maybe we gotta constantly going out there, every weekly to make sure, it's kept clean. But like I say, he can't come out there daily, we live in Newport Richey, this is located in Tarpon Springs.
Yeah, that's a problem. Does the board have any questions for the owner? I've got a couple questions. I live nearby. There's a number of paths that have been created by people stepping certain places, like behind your garage or the side of your garage on the east side. And I see people in and out of there all the time. Is there something going on that we don't know about?
I have the slightest idea, I was just looking at the picture, because I know, as we went there earlier,
Yeah, I saw you doing the palm trees
well,
and
like some
such.
people might be living back there, we're not sure.
Okay.
I want to say, I'm not sure.
Well, there's a lot of traffic in
Yeah,
on
that's
that
the
vacant
area,
lot,
we'll see
that's
that.
for sure.
Like I said, we have no control, and we have, we live on that daily, so I don't know.
Needs to be controlled.
Is it best to put trespassing sign up on the property, would that help? Maybe get
Yeah.
the help from the Tarpon Springs Police Department,
There you go.
maybe that can help from the trash being thrown out as well.
Does the city staff have any questions?
I do not.
Okay.
One question for staff. When this was established. Was there a fine initially?
I don't
set?
have the numbers on my record, sorry.
Couldn't find
I
it
think,
on-
I'm sorry, $25 per day.
Okay, thank you.
Okay. I'm going to tell the audience I'm closing the public portion of this case, and we'll entertain a motion.
Are they in compliance now?
Anybody?
I move based on the testimony, evidence, facts presented, and law, that the respondent, Craig Fowler, was in violation of sections 8-52 of the Tarpon Springs Code from September 30th until October 18th, and a fine of $25 per day. In addition, I move that the prosecution costs of $72.50 be awarded for the costs incurred in prosecuting the case.
Second.
It's
Sorry, who was the
motion
second?
made and seconded. Sorry, Bobby, could you
I
call the roll?
didn't, I couldn't distinguish who the second was. Mrs. Archer?
Ms. Archer.
Thank you, sorry.
It's okay.
Roll call for you?
Call, please.
Okay. Ms. Telliar?
Yes.
Mrs. Archer?
Yes.
Ms. Norfleet?
Yes.
Mr. Robinson?
Yes.
Mr. Kramer?
Yes.
Ms. Wade?
Yes.
Mr. Weeks?
Yes.
Motion carries.
And summarize.
So, Mr. Fowler, you've been found in violation of Section 8-52 of the code. You're considered a repeat violator because it has happened before. You've been found in violation from September 30th until October 18th and fined $25 a day. The Code Enforcement Board has also awarded the city of Tarpon Springs $72.50 for prosecution costs in prosecuting the case. There will be an order entered. It'll be entered within the next 10 days and mailed to you at the address listed by the tax collector and property appraiser. If you have a different address that you wanted to give to Officer Gasson, for example, your address in Newport Richey, they could also send it there. So if you want to do that after the meeting, that would be fine.
There's still a fine that he has to pay? What's the
Yes.
amount? What's the total amount?
I don't have a calculator. It's from 9:30 until October 18th, 18 days, $25 a day. And keep in mind that there's already a fine running on the property at $25 a day since July 20th. That has not been satisfied either. You can talk to code enforcement staff after the meeting. Officer
gonna talk to you.
Gasson, he'll be happy to help you, or Beth will.
Okay, thank you. Repeat violator 19-800000705, 211 East Lime Street. Charles Barrows. Mr. Bowers doesn't seem to be here.
He is not. Thank you, Officer Steve Gasson, City of Tarpon Springs Police Department Code Enforcement. It's a repeat violator case. Current case is 19-800000705 for property addressed as 211 East Lime Street. It is a vacant lot. Parcel number 1327-1501692002-00180. This is a repeat violator for 3 previous cases. Case number 17-800000486, which is a violation of City Code 840 and 852. That fine was $25 per day and totaled $2,808, and that's not paid. Repeat violator, case 18-800000919, also a violation of 8-40 and 8-52. That one was also fined at $25 per day, and there's $1,491 not paid on that one. Repeat violator for case 18-800000099, again for 840 and 852. That one was also a fine of $25 per day, and it's not complied as of yet. Exhibit number 1 going before the board are all the photographs. Exhibit number 2, notice of violation and notice of hearing. Exhibit number 3, administrative documents, case summary, previous board orders, and property appraiser and tax collector records. Exhibit number 4 is the affidavit of posting and a copy of the sign. Exhibit number 5 is an affidavit of the prosecution costs. All the notices are mailed to the property owner of record based upon the Pinellas County property appraiser and tax collector databases. All the notice of violations and notice of hearing are sent both first-class mail as well as return receipt. And Mr. Chairman, please accept all these exhibits into the record as evidence.
please do that? Thank you.
Our office has had contact with the owner. He's come into the office a few times regarding his properties. On September 30th, I conducted the initial inspection, discovered there was violations. I was actually inspecting neighboring properties on Lincoln.
Yeah.
And then noticed some violations over here. There's trash and debris, it's overgrown, the property is less than 10,000 square feet, so as discussed before, it needs to be cleared of all undergrowth, weeds, small trees, things like that. There's also some shopping carts dumped on the property. On September 30th, the notice of violation, repeat violator notice of hearing was mailed, and the mail was returned attempted not known. I'm not sure what in post office lingo that means, but we got it back. Moving forward, on November 1st, I posted the property, and I also conducted a re-inspection, and I noticed that on November 1st, it was in compliance when I posted the property. So the property was in violation from the date of the initial inspection of September 30th until it was complied on, hold on. Why does this have to work? I'll go by my notes because I don't remember everything, so that's why taking good notes is important. And I put it in compliance on October 18th. So our period of time was from September 30th of 2019 until October 18th of 2019. And this again was violation of City Codes 8-40, duty to maintain private property, as well as 8-52, which deals with debris and overgrowth. And that's all the city has at this point.
Does the board have any questions for the city?
It's not in compliance at this point.
It is in compliance, my
Is in
apologies.
compliance.
Yeah, it was in compliance as of October 18th. So from September 30th to October 18th.
Ms. Archer, you have a question?
Yes. What do we do? This is like the third repeat, right?
Well, it's up to you guys.
But what do we do about getting this money? He owes a lot of money.
I can answer that question for you.
Thank you.
You know, there are certain cases that are brought to the city attorney's office for collection, other cases aren't. The small dollar amounts, even though this seems like a lot of money, the small dollar amounts are normally not pursued. They just wait until the property is conveyed and then, you know, pick up the fine amount at that time. The thing about code enforcement liens, though, is that any one of these liens attaching to any property that Mr. Burrows owns is cross-collateralized by the other properties. So if he tries to sell one, he's gonna have to pay all the liens on all the properties. If this was over $3,500, I think that each case is over $3,500, I think that we may be doing something a little bit different, but these, we consider small dollar amounts because the city takes into consideration attorney's fees and costs, and it doesn't make economic sense to spend that kind of money on small cases like this. So eventually it will be paid. It may be some time before it gets paid.
Okay, thank you for explaining.
Sure.
Anybody
The other
else?
thing to consider, I'm sorry, is
Yes.
my repeat violators might not necessarily be for the same property. So he could have other properties that were in violation, but because he owns them, it's on him for all of them that are in Tarpon Springs.
And close the public portion of this case. I'll entertain a motion.
I move that based on the testimony and evidence and facts presented and the law, that Mr. Charles E. Burrows was in violation of sections 8-40 and 8-52 of the Tarpon City City Code from 9/30 to 10/18. And such time the property was brought into compliance, and a fine of $25 per day shall be imposed until compliance is met. In addition, I move that the city be awarded $72.50 for costs incurred in prosecuting the case.
Here, second?
Before I second it, would you consider raising it to 50, because this is a over and over and over?
Would, yes, but, yes.
Okay, I'd second it at
Amended
50.
to
If I can
50.
do that.
Okay.
And I think we need to, I didn't quite hear you. It is now in compliance.
Okay. It is brought into compliance. I said that, I believe.
Okay, can we get a second now?
Yes.
Second, okay. Bobby, roll call?
Yeah, so just one moment, please. I'm sorry.
Dear.
There we go. Mrs. Yes. Mrs. Archer?
Yes.
Ms. Norfleet,
Yes.
Mr. Robinson?
Yes.
Mr. Kramer?
Yeah.
Ms. Wade?
Yes?
Mr. Weeks?
Yes. Repeat violator number 8. Repeat violator 19-800000729, 608 North Avenue, Robert Winwright.
Mr. Chairman, he also needs to be sworn in.
Mr. Winwright, you need to be sworn in by the secretary, please.
Hi, sir. Do you swear the testimony you're about to give the whole truth, none but the truth? Thank you, sir.
Mr. Winwright, do you have any objection to the evidence that the city has presented? Legal evidence, legal objection?
Pickup day was, what, week, the pickup day. And we just brought
Doesn't understand the question.
The furniture was just put out there
Okay.
and getting ready to pick up.
Needs the microphone.
Could you put the microphone, sir?
Put the microphone to your face, please. And,
Yes.
I meant, do you have any legal objection to the evidence that's been presented by the city?
Oh, no.
Just yes or no?
No, sir.
Thank you. Okay,
Thank you.
go ahead.
Officer Steve Gasson, City of Tarpon Springs Police Department, Code Enforcement. Case before the board is case number 19-800000729. Property address is 608 North Avenue. The property owners are Robert Winwright and Henry Knight. This is a repeat violator case. The case for the previous one was 17-800000647. Violation of City Codes 8-22, 840, 852, and 6-1. The previous fines on that case were $50 per day. They totaled $3,116.50, which are currently unpaid. Exhibit number 1 going before the board are all of my photos. Exhibit number 2 is all of my notices to include notice of violation and notice of hearing. Exhibit number 3, administrative documents, case summary, previous board orders, and a copy of the property appraiser and tax collector database records. Exhibit number 4 is the affidavit of posting and a copy of the sign. And exhibit number 5 is the affidavit of prosecution costs. All of my photographs and exhibits given to the violator are exact copies of what's being presented to this board. All notices were mailed to the property owner of record as determined by the Pinellas County property appraiser and tax collector databases. All notice violations and notice of hearings are sent return receipt as well as first-class mail. Mr. Chairman, please accept these into the record as evidence.
Bobby Dussault, when they get down to you, please.
Yes, sir.
Thank you. We did have contact with the owner via phone. The case started on October 9th of 2019. There was a pile of trash and debris at the front curb, as you can see in the photographs. As Mr. Winwright's more than likely going to state, there was a fall cleanup time. The issue is the city of Tarpon Springs doesn't allow you to put your trash out more than 12 hours before, even if you do have fall cleanup. And when you're a repeat violator, you're not allowed to violate that basically at all. So on October 9th, the repeat violator notice of hearing was mailed. The green card was returned signed. On October 14th, I conducted a reinspection, and at that time, it was in compliance. November 1st, I posted the property and signed the affidavit. So the property was in violation from the date of the initial inspection of October 9th until October 12th for a total of 3 days. And it was city code violation 8-22, accumulation of trash, and 8-52, nuisance prohibitions, which deal with debris, which is like old furniture and things depicted in the photograph. And that's all the city has at this time.
Does the board have any questions of the city?
I'm sorry, ma'am?
You mean 12 or 14? Reinspection, is that when you,
I have the reinspection, no, they contacted our office on the 12th. I reinspected it on the 14th, so that's why it's the 9th to the 12th.
thank you.
Other questions by the board? Mr. Wainwright, do you have any questions of the board, of the city?
You're in compliance.
Yeah,
Questions, just questions.
okay. The last time, they gave us 2 weeks to put the trash out, to stuff to the curb. But now he says 12 hours. But it's just a matter of a few hours of what the time is for put the trash out to the curb, which in pickup day, everybody has stuff going out to the curb. There's more people on the block just getting ready to put the stuff on the curb too.
No questions, though?
Well, how can we be nuisance and we're just putting trash to the curb for pickup day. This is,
Okay, that's your question, and how can it be a nuisance?
Well, it even says in the notice that was sent out, place items by the curb by 7 a.m. to be picked up. There's nothing in the notice that was sent out that gives you up to 2 weeks. Unfortunately, Mr. Winwright's property is a repeat violator. I received a complaint about debris being out at the curb about 10 days before it was fall cleanup. So I handled the complaint, and that's where we are. So.
Okay.
basically, we just had got new furniture. It wasn't like we're dragging it out the backyard. And as you can see, it's plastic on the furniture there for the Goodwill pickup or whatever for the old furniture. And
Want to present your case now? Thank you. Is that what you're doing?
I don't know. This is not what I do.
Okay.
So
All right.
maybe
Well,
I'm out
what
of
we're
line.
asking you to do now is just present a case. What kind of a case do you have in reference to this evidence?
Well, basically, this right here, as you can tell where the trash is, that's on property that was actually grandfathered to us to use, again. But the same thing goes again. We don't have any room to do anything because they put a fence there when we was grandfathered in for the property. So we can't hide technically take that, we have no room to take it back and hide it because they closed off our gates. Off our backyard and stuff. So therefore, it's just sitting there because of the fact we was violated the property of using it. So now here is another nuisance thing here, and all of this other stuff goes with us getting violated of our own stuff from the, I guess, the housing community there, which.
Code enforcement, yeah.
We're getting violated of our own property.
Right.
Actually. And, we're not trying to cause any problems here.
Yeah.
We're just trying to live in our own house here. And then this city housing stuff is getting more than the house users, the users of our household. You know what I mean? Our household we're house owners. We're getting a lot of problems with this housing authority here next door, which is obviously the one that called you, and he is giving us a lot of problems. We're house owners, not the housing people. So we get a lot of problems from the housing people, which we shouldn't be getting.
Well, that has nothing to do with the,
You understand that you can't leave stuff piled out like that?
Yes, ma'am. But we would have had it hidden if they had not put that gate up there. And if the gate can go farther out, which we told them.
It doesn't matter if it's in your backyard or your front yard, you can't leave all that stuff. You have to either pay to take it to the dump, or pay to haul it away, or store it inside until
Yes,
it's the
ma'am.
day.
or hide it.
Yes, ma'am, pickup day was coming. And we was under impression from last time, that pickup day, they gave us 2 weeks. This time, they changed it on us. If you read back in your paper, they send the paper saying actually gave us like 3 or 4 weeks to put it out.
That was for a previous violation.
They carried this violation into that one,
But
still.
once you've been previously violated, it starts immediately, and that paper does say that.
Right, but this is the same thing here. You saying this was a previous violation. They gave us 3 weeks to put it out for the pickup for the curb. But
Don't give you 2 weeks anymore.
Well, the notice is on the board.
we didn't get that notice.
Or does it say 3 weeks?
Oh, you're talking about the fall cleanup notice, not your violation notice?
Yeah.
We had cleaned up right after they told us that we was in violation.
The previous one, he wasn't a repeat violator. Now he's a repeat violator. We
you
don't
don't
give
get
him a
any time
time frame.
after
It's
that.
immediate.
Right. So we had the previous one. They gave us 3 weeks to put that trash out, but now they're giving us 12 hours. So here we is again in violation of something that's already done.
Okay. Does staff have any questions
I do not.
for the owner? We're going to close the public portion of this right now, and I'll entertain a motion.
I'll make it. Robert Winwright and Henry Knight was in violation of sections 822, accumulation of trash, and City Code 852, nuisance prohibitions of the Tarpon Springs City Code from October 9th, 2019 until October 12th, 2019, and a fine of $25 per day for 3 days, or a fine of $75. In addition, I move that the city be awarded $69.50 for the cost it incurred in prosecuting the case.
Second.
Been motioned and seconded. Bobby, could you make a roll call, please?
Mrs. Telliar?
Yes.
Mrs. Archer? Ms. Norfleet?
Yes.
Mr. Robinson?
Yes.
Kramer?
Yes.
Wade? Mr. Weeks?
Yes.
Motion carries.
Thank you.
So, sir, you've been found in violation of Code Sections 8-22 and 8-52 from October the 9th through October the 12th, a total of 3 days. The Code Enforcement Board has entered a fine of $25 a day and also has awarded the City of Tarpon Springs $69.50 in prosecuting the case. There will be an order entered. It will be done in writing. It'll be sent to you within the next 10 days. If you don't understand what has happened today, you can talk to the code enforcement staff after the meeting or contact them at some other time. Do you understand?
Okay, yes, I have a question then. How do I go about being in compliance with that gate that's there?
So you can talk to the code enforcement staff after the meeting. This board does not have the authority to give you advice on handling that type of matter, but code enforcement staff can answer your questions. So either Officer Gasson or Beth Hughes or someone on their staff would be able to help you. Okay?
Okay.
On to the next case, repeat violator 19-800000786, 722 Merlin's Court, James Bauer. Mr. Bauer here? Doesn't seem to be. Okay, sir.
Thank you. As stated, this repeat violator case, I'm Officer Steve Gasson, City of Tarpon Springs Police Department Code Enforcement. The case before the board is 19-800000786. The property address is 722 Merlin's Court. Property owner is James Bauer. It is a repeat violator case stemming from two prior cases. Repeat violator 18-8000086 for violations 8-40 and 8-52. That one has fines of $100 per day, totaling currently approximately $55,686.50, which have not been paid. Repeat violator for case 17-800000244, same code sections 8-40 and 8-52. There was no fines. It was established only under that case. Exhibit number 1 going before the board are all of my photographs. All my notices to include NOVs, or notice of violation and notice of hearing, are my exhibit number 2. Exhibit number 3, administrative docs, case summary, previous board orders, copies of property appraiser and tax collector records. Exhibit number 4 is the affidavit of posting and a copy of the sign. And exhibit number 5 is the affidavit of prosecution costs. As you're aware, my notices are mailed to the property owner of record as determined by the Pinellas County property appraiser and tax collector databases. All notice of violations and notice of hearing are sent, return receipt as well as first class. And Mr. Chairman, please accept these into the record as evidence.
Bobby, when they get down to you, please accept them as evidence. Is the, go ahead.
Thank you. This is an occupied residence. From my understanding, Mr. Bauer does live there. We've had no contact with the owner. The case began on October 31st with the initial inspection. The property was overgrown. There were some other parts of the complaint that weren't really a code issue, so I was just strictly dealing with the overgrown property. On October 31st, the repeat violator notice of hearing was mailed, and we received nothing back. November 1st, I posted the property, and an affidavit of posting was also signed. So it's currently not in compliance, so it is still in violation from October 31st. For sections 8-40, duty to maintain private property, and 8-52, if the board didn't see it, I have the photographs up on the board, or they'll come up here in a second. Basically, the property is here on the left, and it's grossly overgrown. And here's another view. Merlin's Court's obviously the street out front, and his property is where the black Lincoln is in the driveway. And I can't see the backyard. I don't have a very good picture of it, but it appears that it's also overgrown from what I could see. And that's all the city has at this time.
Does the board have any questions for city staff? Let's go ahead and close this public portion of the case, and I'll entertain a motion.
I move based on the testimony, evidence, facts presented in law that the respondent, James Bauer, was in violation of sections 8-40 and 8-52 of the Tarpon Springs Code from, confirm the dates for me again?
It's not in compliance. October 31st was the starting date.
From 10/31st until current time, and until the property is brought in compliance, a fine of $200 per day shall be imposed until compliance is met. In addition, I move that the city be awarded $69.50 for the cost it incurred in prosecuting the case.
Second.
Bobby, can we have a roll call, please?
Ms. Telliar?
Yes.
Mrs. Archer?
Yes.
Ms. Norfleet?
Yes.
Mr. Robinson? Mr. Kramer?
Yes.
Ms. Wade?
Yes.
Weeks?
Yes.
The motion carries.
Affidavits of non-compliance. 18-8000235.
I move we accept that affidavit of noncompliance and award the city $182.50 in prosecution costs.
Need a second?
Second.
Mr. Chairman, I think somebody might be here for that.
That case.
Is there anyone here in the audience on this case?
It's the Pappas, or the Rainville Pappas Civil Contractors.
Okay.
Would you like to?
So before you act on that motion,
Yep.
we just need to find out. Sure, is there, if you could state your name, please?
Creek Work Sargent. I'm with Gulf Coast Consulting, civil engineer on the project.
Anything that you wanted to add today?
Only here to ask for an extension.
Okay. So what type of extension are you looking for from the board?
I understand initially when there was a non-compliance meeting, 6 months was given during, I was not present, and I think the client also was not present, so there was nobody really to have a conversation. The 6 months was provided as a date to complete the site planning. Just as a little background, the project is also had some code violations with the Southwest Florida Water Management District, which at this time has been closed, so that's been resolved. And as of yesterday, we did make a submittal for a site plan. The site plan did change based off of the information we got with SwiftMud. The site previously was permitted with SwiftMud, and so the initial drawings that were provided were based off of that permit, which has since expired. So SwiftMud had come back and redelineated the wetland limits, and because of that, the whole site plan changed. So we provided a new site plan and made it a new submittal, which we just submitted yesterday.
I have a question. So you began excavating and filling before you had approval from SwiftMud and the proper permits?
From my understanding, the client made some changes to the site without a permit. That's my understanding. I'm not the client, I don't know.
Thank you.
How much time?
I would say 3 months is typically what it takes to get review process through.
What does the staff have to say about that?
Well, what happened was they acquired the property and almost immediately ripped out somewhere to the tune of about 180 trees. They had a previous tree case that I think we established like 96 trees that were unlawfully removed. That was part of my code case because they also, in clearing that, leveled the ground, brought in fill, brought in asphalt millings, created a parking lot. We're beginning to use it for its use and had not contacted the city in any way, shape, or form. My case was relating not only to site planning, but the building permit requirements, obtaining building permits prior to doing any work. We went back and forth for a significant period of time prior to coming to Code Board. I think I want to say there was upwards of 6 to 8 months. And then we gave them another 6 months on Code Board. And now we're revamping the whole plan. I think the city is at a point where, you know, I don't know if 3 months, to be in compliance is the building permits have to be finalized. I mean, we have to be done, not just submit a site plan. That's only one aspect of the case. There's the site plan dealing with the excavation and fill. The property hasn't been put back into its state, and they have obtained no permits for the fill that they did do. As I stated, the building permits need to be finalized, and then, well, 6-1 is just us adopting the building code. But it's a significant, it was a large piece of land that was affected.
Huge.
Yeah, and the trees were the beginning of that, but that was dealt with separately, so.
And they were using it for a particular use already?
They began to, and we obviously wouldn't allow them. They wanted to park vehicles on the property, and nothing had been asked, obviously, and I think he got brought in second. I don't know if he was the second developer or how that whole process worked, but we sat down, had a meeting upstairs with everybody involved and gave them a significant amount of time to work through this. Nothing occurred, hence we came to Code Board, and I think I even asked for giving them another 6 months just because it is an expansive kind of a thing. Obviously, it's not, the board's decision. The city's position would be, I think we've run our course, and we'd like to, you know, move forward with that, and I don't think another 3 months of site planning is going to fix it. You know, they can reverse everything they've done out of it, and then the case would be closed. Then they can go through the process at their own time frame, but they have to undo what they've done to the city's approval.
And how do we impose that?
Huh?
How do we help impose that?
He undoes everything they brought in. I mean, you can't undo the trees. That was a different case. That's done. But all of the fill, the millings, the creation of the parking lot, all of that can be undone. Clean slate, case is closed. They can take 10 years to site plan it and develop whatever they want to develop at that point. So that's the city's position.
This across from 71.
I don't know that.
I'm sorry.
Can I speak further, or?
71.
No, just so you know, ma'am, this property is the northeast corner of alternate 19 and Rainville Road, across on the north side of the church up there, the Irish church.
Northwest corner.
Huh?
Northwest corner.
I'm sorry?
Northwest corner?
West.
Did I say northwest?
You said northeast.
I meant northwest. It's the northwest corner. My
That
apologies.
is mine.
Big fence.
I knew what he meant.
I knew in my head where it was.
I'm not unclear as to how we help make that happen.
Right, yeah.
Okay, so your options are, first of all, you have a motion on the floor to accept the affidavit of noncompliance. So if you want to do something other than that, the maker of the motion needs to withdraw the motion. The other option would be a motion to extend the compliance date, and you would set that again by motion today, if that's what you wanted to do. So for example, extend the prior compliance date until 3 months from now, if that's what you're thinking, you know, whatever, February. And then that would be the motion. Otherwise, you can accept the affidavit of compliance. They can bring the property into compliance and come back and ask for a fine reduction.
Second.
What?
We already have a
Wait,
motion.
we already
We have a
motion.
motion on the floor.
So I just seconded the motion.
Can I,
Repeat the
can I,
motion.
Had the mo-
The
Can I-
motion is to accept the affidavit of noncompliance on the floor right now.
can I provide additional explanation?
Go ahead,
So
shortly, quickly.
initially, the project was designed so there's some warehouses to be built. The property itself is in a flood zone. It's at flood zone elevation 10.
Yep.
The ground itself right now is at 3, so that means there would be like 6 or 7 feet of fill that would be required to bring this, to build a building. In our initial design, so there would be tremendous amount of fill, there would be some ponds that would have to be put into place. After meeting with SwiftMud, and we went back and forth with SwiftMud for several months until the gentleman, the scientist got to the site to help establish the line and then finally confirmed that that's the line that he wants. So the wetland line moved into the site significantly, made the site less developable than what we had initially thought of. So he went back and he looked, and we did a new design. The new design is looking at an RV boat storage facility. So there is no buildings per se, it's basically cover over parking spaces. So the new site plan does not need the fill that it needs before. But again, with wetlands and some floodplain areas, there's some compensation that needs to be done. So in efforts with SwiftMud and with their guidelines, a lot more trees are going to be taken down because of the fact that we have to provide for floodplain compensation that we're impacting with a little bit of fill. So, yes, some trees were taken down in the site, any site development, including whatever we're proposing here. More trees will be taken down. So,
But you have to have a permit, right?
Okay, thank you.
True. Yeah, just do the process.
I'm going to close the public portion, and we have a motion and we have a second.
Yeah.
Do you want to repeat the motion?
No, I
No,
think.
we got it.
I think it's fine. I just
Like to
wanted,
hear it.
I wanted to make a comment.
The motion is, the motion was to accept the affidavit of non-compliance, and there was a second.
And that's what I think we should do.
Okay,
And the rest of this is already between them and the city right now. It's already there. There's
Okay.
already more issues than they need. As an old contractor, I can tell you the problems they've been having. But
Is
I
it
think
too
we
late
just
to ask
accepted
him one
and
other question?
we did our job.
yes,
It is too late?
no, no more questions.
Okay. I just
Okay,
wa-
because we have a motion on the floor
second.
and we have a second. We
Yes.
need to vote on that motion.
Mr.
If
Trask,
you would do a roll call,
there's
please,
an
Bobby?
affidavit of
Wait, wait.
non-compliance on it too. I don't know if that has to be included in the motion or not.
Why?
Or prosecution costs, sorry. It was added? Okay.
Yes.
I just didn't hear it, sorry.
Can I just make something clear again? Or- Trees were taken out without a permit? Were they supposed to have a permit?
That was all handled in a previous case, a different case other than this case. We did two separate cases for that. And
Okay.
the city, and they've already made all their reparations with the city under that case.
Okay, and what about the fill?
That's
Same
all,
thing?
That's
old
this
news.
case. That's what's
So
here
they brought in
now.
fill, which was not,
Yeah.
they were supposed to get permit for that, or?
Correct. They did site work without any communication with the city at all, other than they got their zoning change. That was all.
They did get the zoning change?
Yes, they had the property zone changed, and I believe within a couple of days after that, they were in there clearing the land. So,
Bobby, roll call, please.
To accept the affidavit of non-compliance, and that's what's on the
With-
floor,
Yeah, with the
correct?
prosecution costs of
And
182.50.
182?
Yeah.
Thank you, sir. Mrs. Tillier, yes. All right, messed this one up. Mrs. Archer,
Yes.
Ms. Norfleet,
Yes.
Mr. Robinson?
Yes.
Mr. Kramer?
Yes.
Ms. Wade?
Yes.
And Mr. Weeks?
Yes. Affidavits of compliance. 16-800000582, 401 South Levi's Avenue.
I move we accept that affidavit of compliance.
Second.
All those in favor say aye.
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 All those opposed, same sign. Motion carries. 18-800000644.
I move we accept that affidavit of compliance.
Second.
All those in favor say aye.
Aye.
All those opposed, same sign. 18-800000985.
Move we accept that affidavit of compliance
Second.
and award the city prosecution costs of $175.
And it's seconded. All those in favor say aye.
Aye.
All those opposed, same sign. Motion carries. Okay. Motion to amend Board Order 19-800000555, 201 North Pinellas Avenue.
this was a request of the city to correct a date on the previous board order. After looking through the records, through the emails and everything, the city is asking the board to consider moving back the compliance date on this case. should be changed to August 13th due to information received after the hearing. So that's what the city's requesting.
On all 14, 15, and
Okay.
16.
This is the compliance date, right? Change from the 16th to the 13th?
Correct. We're backing it up 3 days.
So moved. Let's change the date on compliance to 8/13.
Second?
We have a motion on the floor to change the compliance date to 8/13, and it's seconded. All those in favor say aye.
Aye.
All those opposed, same sign.
Aye.
So there was one.
One
na-
dissent.
One
One
nay.
dissent. Mr. Kramer, is that correct?
Yes.
Petition for rehearing 19-800000555. This is the same one? Oh, I understand. Go ahead.
I make a motion that we deny the petition for rehearing.
Second.
All those in favor say aye.
Aye.
All those opposed, same sign. Motion carries. Fine reduction request 19-800000555.
Make a motion that we deny the fine reduction request in that case.
Second.
Motion and a second. All those in favor say aye.
Aye.
All those opposed, same sign. Motion carries. 18-800000181. Motion to quash.
Correct. There was changes with the property, or there was issues with the property owner of record at the time the board order and everything was established. So the city requests that the board quash their previous order because it was basically attached to owners that the record wasn't correct for. So it's a kind of an invalid board order per se.
Were those the people that changed the ownership the morning of the?
There was a lot of legal things that were going on with foreclosures with the bank, and then foreclosures were vacated, and we just caught the records at the wrong time. And they're still not updated, so we're kind of waiting until everything levels out, and then we'll bring forth the case.
Answer your question.
So let me explain it to you. Okay.
Better
So
than me.
The mortgage company began a foreclosure process. It went all the way to trial. At the trial, the court entered a final judgment of foreclosure, awarded the bank what it was entitled to, ordered the property to be sold. The property was sold, the bank took title, and once the bank took title of the property at the judicial sale, there was a motion made by someone, probably the owner of the property, to rescind and remove the final judgment. And so what happened is the judge went back and he said, okay, I'm removing the sale date, I'm removing the final judgment. And so now it's back in the hands of the property owner again, and then the process went a different direction. It just so happened that the code enforcement case hit right after the bank got title to the property.
Okay.
So they appropriately served the case on the bank, but when the judgment was reversed and the judicial sale was set aside, it basically put the case in no man's land. And so they're trying to clean it up to make it accurate so that there is no wild lien on the property because of it not being the appropriate property owner.
Thank you.
Long version of what they're trying to accomplish. They're trying to clean it up.
Thank you, Doctor. I feel better.
Okay.
Motion to squash 18-800000181, 445 East Martin Luther King Drive. Can we get a motion?
Motion.
Motion to squash. Second?
Second?
Second.
Don't forget award.
Don't forget the 12750.
That'll come on to the next time when it comes up again.
Yeah, we're not going to deal with that today. If we're setting it aside, there should be,
Okay.
We're setting the whole thing.
All right.
there shouldn't be a word.
All right, we have a motion and a second. All those in favor say aye.
Aye.
All those opposed, same sign. Motion carries. Amended affidavit of compliance. Compliance date amended to 6/10/2019 administrative era, 18-800000555 491.
I make a motion, we amend the affidavit of compliance to the correct date.
And on the floor in a second to make it to the correct date, which is 6/10/2019. All those in favor say aye.
Aye.
All those opposed, same sign. Motion carries. A fine reduction request, 18-800000644, 1017 Beaver Drive.
I move that we do not reduce the fine in that case.
The motion on the floor to not reduce the fine? Do I hear a second?
Second.
Second. All those in favor say aye.
Aye.
All those opposed, same sign. Motion carries. A fine reduction request 16-800000582, 401 South Levi's.
Levis.
Levis.
Correct.
Can I get a motion? For
I move that the fine of $440,000 in case number 16-800000582 be reduced to $10,000. This fine reduction will occur upon payment of the stated reduced amount if paid within 60 working days of this order. Failure to pay the reduced fine will revert back to the original amount of $440,000.
Do I hear a second?
Second.
Discussion?
I have a question.
Sure.
Why is this person not a repeat violator? New business number 2, she was in violation of she had 3 violations. Although they're not the same as this, why is she not a repeat violator?
That's a 2016 case we just heard for the fine reduction request, and she's in the process of selling the property. The new buyers are attempting to acquire that property out, but obviously can't with $430,000 worth of fines. So they're looking to develop that area and that property, and that's the reason why we're in this situation. But that case was started in 2016, then the other cases came after that. She is now, because she's been to code board, but at the time, I think it was actually, she had some changes with quitclaim deeds because of family members, like her parents' house, and then
they
she
died.
got it through a quitclaim
she
deed,
ended up
and then I think there was some estate things. So the house has kind of changed property like 3 times in the last few years.
So she's trying to get this reduced so she can sell it without that huge lien on it? Is that-
Get out from
Nobody's gonna
underneath
buy
it.
it for $440,000.
That's the question.
Basically, the buyers are here, and the sale can
Not
go
gonna be
through
involved
and be
in this
developed.
anymore.
Huh?
She's just trying to get her fine reduced so she can sell it.
Correct, and we can develop basically an uninhabitable property.
Gotcha.
Yeah, and put a house on it.
Okay.
Well, we can't, they can.
The whole block's not worth $440,000.
No.
Okay, I need a motion.
So we have a motion.
We have a motion.
Motion and a second.
And a second. Oh, okay. Any further questions?
Got
I fell asleep there for a second. All those in favor of the motion, say aye. Aye. All those opposed, same sign. Motion carries. Do you have any minutes that we need to get approved? No. Public comments?
I referenced this last case, like I said, this is an opportunity for the city to develop some property that probably would have just ended up remaining stagnant for an unknown period of time. Some developers came in, expressed their desire to put new housing in that area and, for lack of a better term, spruce it up, make it habitable. So this was a unique opportunity for us, and that was the reason why we had recommended the reduction in fine to what it was, so that the sale could go through and the property could be developed. So, and I'm hoping that we may have some more of these coming up in the future. So in an effort to do exactly what this code board was designed to do.
Give them a try.
So I
to see how
appreciate
it
that.
comes out.
I want to thank Annie
Dabbs?
for all her work on the code board. She's going to be missed. And I saw Mayor last week, Alahuso, and he said to tell everybody that he appreciated all the hard work we're doing, and it shows. So thanks.
And we want to welcome our new members.
Yes.
Welcome back.
Welcome back, Ms. Archer.
Here we go again with his name.
Okay.
Fun stuff.
We are dismissed.
For 10 grand.